told us that he will appoint a vice president if it increases the sufurias of ugali in our houses. We were told this is the worst thing that has ever happened. There's a vacancy. Answer number one, Article 148 does not, no, not 148, sorry, I believe I'm talking about the sequencing where the Speaker of the National Assembly is the third in command, so to speak, when there's a vacancy. I have been waiting for my good friend Mr. Milimani, who represents the Speaker, to shoot up to his feet and protest loudly that his client is not a vacuum. Because the Constitution says, when, I think it is, this is Article 146, Sub-Article 2B. If the office of Deputy President is vacant, or the Deputy President is unable to assume the office of President, the Speaker of the National Assembly shall act as President, and an election to the office of the President shall be held within 60 days after the vacancy arose in the office of the President. Two things to note there. In that article, the framers of the Constitution contemplated a vacuum in both the presidency and the deputy presidency. And it is at this point where my good friend Mr. Milimo says his client, Anatosha.
My Lord, I have not said that.
Maybe you'll say it. I am almost certain in the event that my good friend Mr. Kamoto described here a few days ago, when he said the president might go to where people don't come back from, that we will all say Wetana Tosha.
I never said that.
He did. The record says so. Yeah, but we understood him. He was not wishing ill. So that's the first thing. The second thing, my Lord, is that they contemplated we can operate for 60 days, 2 months, without either a president or a deputy president. The world will not collapse. Kenyans made adequate arrangements for the caretaker, while those two are not with us. And there seems to be something magical about these 60 days that Kenyans clearly had. Because under Article 149(1), when the deputy president is impeached or there is incapacity, the president has 14 days to nominate a candidate to the National Assembly. That is number one. And because it is not obvious, or it is not a matter of course, that the National Assembly will approve that candidate, it must be contemplated that the National Assembly can refuse to vote for that candidate. So those 14 days can be repeated, which is what the Constitution says. If Parliament rejects the first candidate, the process is repeated again. And the Constitution seems to contemplate can be repeated almost indefinitely until the President comes up with a name that is acceptable. So that is number one. And there's no crisis. The world will not end as Parliament rejects those candidates. So that's number one. But the President having nominated a candidate, the National Assembly itself has then another 60 days. So we can again operate as a country for 60 days without a deputy president. And so I return to what the Supreme Court said in the Sonko case we must do, and has not been done, has not been afforded to our client, the Deputy President. This is what the court says. This is the Supreme Court again at Article 114. And it's interesting because what had happened in the Sonko case, the court actually found that Sonko was not properly before it. But they then said they converted the proceedings into an advisory opinion. So they're actually giving this as a template for courts, such as this honorable court, to follow. Paragraph 114. To the question whether due process was followed in the removal of the appellant, the Audi Alteram Partem rule requires that those who are likely to be directly affected by the outcome of a decision should be given prior notification of the action. So they give a whole list of what must be done. Prior notification of the action proposed to be taken, of the time and place of any hearing that is to be conducted, and of the charge or case they will be called upon to meet. They must be given an opportunity to be heard. Now, it is not a matter in dispute that on the night the Senate, I and my colleagues on both sides were present in the Senate, our client was taken ill. I have subsequently read in the newspapers he had a broken heart for good reason. So he is taken ill, and the Senate then takes a vote. And this was important because the Senate had 2 days left, even in their own self-prescribed time limits. They voted, and this was not an electronic vote. They voted on acclamation to reject a motion to extend time for the deputy president to appear
My
in
Lord,
court.
if I may, I am compelled to interrupt. My Lord, learned counsel is misleading the court. When on affidavit, it is clear that the Senate votes
I don't have a seat.
electronically. Senate does not vote by acclamation. I do not know what paragraph is addressing himself. Perhaps he can point the court to the paragraph he's addressing himself to on the question of acclamation. We can't just sit back and watch Mr. Macharia mislead the court.
I was personally there. Senior counsel Mwite was there. The entire team, most of them were there. On the question of extension of time, it was by acclamation. All the ayes and all the noes, that's what it was.
And the senator was loud.
Yes. And I would ask him to please wait. He'll be a bit more bothered when I finish with my submission, so he can be bothered fully when I finish. So this is what the court says. They must be given an opportunity to be heard, to call witnesses, to be represented by counsel, to be availed adequate time and facilities to prepare, and if the accusations are proved, to be given the reasons. This is important. The Supreme Court says you must be given reasons for your decision. There are no reasons. They voted on grounds submitted to them by the National Assembly. They did not give reasons for that decision. Of course, beyond there, they are also entitled to challenge the decision. Again, you've been told these decisions are not challengeable. The Supreme Court says the accused must have a right to challenge the decision, if against them, before a higher court or tribunal. At paragraph 115, Article 47 of the Constitution enshrines the right of every person to fair administrative action. The manner of actualization of those rights have been enacted in the Fair Administrative Actions Act. Now, when this Honorable Court retires to do its ruling, I would invite you, with tremendous respect, to pay attention to sections 4 and 5 of the Fair Administrative Action Act. They're important in more regards than one. Senior Counsel Paul Mwite has alluded to the question of public participation, and so will some of my colleagues who will come after me. When the National Assembly conducted what it called public participation, it did not avail to the public the response by the Deputy President. What they did is prepare a charge sheet, a copy of which you will find as Annexure 8 of our affidavit in support of the petition, which for ease of reference is at page 498. That charge sheet asks 3 questions. It first sets out the 10 grounds that the motion promoter had set out, and then asks people, do you agree that the Deputy President should be impeached on these grounds? Do you not agree? And then there was a third one, other. That was it. They were not told what his response was, nor was he given an opportunity prior to this process. Because the only way, and you'll find that this is one of the things the Supreme Court says under the Article 47 in Fair Administrative Action Act, the participants in this public participation must know both sides of the story to make an informed decision as the people who voted in this manner. The court then goes on at paragraph 116. In the process of removal of a county governor, and for this case, the deputy president, the right to fair administrative action under Article 47, and the right to fair hearing under Article 50 of the Constitution, all accrue, and I'm paraphrasing here, to the deputy president before a decision to remove him or her from office is reached. And